My name is Charles Allen. I'm the Ward 6 Council member and chair of the Council's Committee on Judiciary and Public Safety. Today is Thursday, April 8th, 2021. We're operating over the Zoom virtual platform this morning. The time is now 9:35 a.m. and I'm calling to order this public hearing of the committee. I want to note that we're joined by Councilmember Christina Henderson. Good morning to you. And I'll turn to you in a little bit for an opening statement. We have two measures before the committee today. Both relate to the topic of criminal record sealing and expungement. The stated purpose of our first bill, which is Bill 24-0063, the Second Chance Amendment Act of 2021, is to amend Chapter 8 of Title 16 to increase the number of eligible convictions that may be sealed, to reduce the number of years a resident must remain, quote, off-papered, to seal an eligible conviction, to simplify and shorten the process that a resident must undertake to seal a charge that doesn't end in a conviction, and to have a group of independent legal experts consider ineligible misdemeanors and felonies and issue a report with recommendations for eligibility. Bill 24-63 was introduced by the chairman at the request of the mayor on February 2nd of this year. The stated purpose of our second bill, Bill 24-0110, the Criminal Record Expungement Amendment Act of 2021, is to expand the definition of an eligible felony and to make all misdemeanors eligible for sealing. This bill was introduced by Councilmember Trayon White, along with myself and colleagues, Councilmembers Robert White, Nadeau, and Louis George on February 25th. Our goal today is certainly to talk about the two specific proposals before us, but also more broadly to consider the topic of sealing and expungement reform and the various decision points that are in front of this committee. And although today's agenda is only on the two bills that have been pending in our committee when we filed the notice, I do want to note we've also had another bill introduced recently since that time called the Restore Act, and I'm sure we're going to engage on the issues raised in that piece of legislation as well. I also want our witnesses to be thinking throughout the day about why we're having this conversation. Why have we historically thought of moving beyond a criminal record as a reward to be given only to those that are most deserving? Because that line of thinking doesn't appreciate the reality that a record can mean the door is shut in your face. A record can mean that you're out on the street without housing. A record can mean that you can't work in entire professions. A record can mean that you can't volunteer at your child's school. We can't think of full participation in society as a reward. It's a right, and it's also the safer and more just policy decision for all of us. When those barriers are lowered, our neighbors with criminal records are able to more easily integrate in society, and as a result, are much more or less likely to reoffend. We know that our current record sealing laws are archaic. They are very difficult to understand. They're incredibly limited in the relief that they provide and place almost all of the burden on the person seeking the sealing. You are at the greatest disadvantage if you have a felony conviction because there's only one eligible felony for sealing, and that is failure to appear. And you can't pick up any other arrests, charges, or convictions for 8 years to even apply before trying to seal that offense. Suffice it to say, this isn't a system that works for the tens of thousands of people with new records created every year in the district. So it is time to expand eligibility, speed up and automate the process, and make it more lay-friendly, and provide legal support to make the promise of these bills real. For me, we're not here to talk about if we move forward, because I want to make very clear we are. It's a question of how we do that.